Hello everyone, so I'm back with the series on IPR and Cyber Law paper 2016 for TY B.Sc IT SEM 6. My name is Professor Tirup Parmar. In last lecture, we have completed our discussion till question 4, sub question C, and in that we have already done with the discussion, that is advantages of IP licensing. In this particular video, we are going to continue our discussion with disadvantages of IP licensing. As we already discussed in our advantages section, that if I have some unique idea but I don't have any investment, so I don't need to worry about. Why? Because officially I can hand over my intellectual property to some second party, and in return I can earn profit out of it. So I can actually utilize my knowledge or my skill in very proper or in very useful terms, or 100% utilization of some person's skills. Now at the same time, there are some advantages for big companies as well, like they don't need to invest too much money in research and development. Why? Because they can directly find person who have already researched or who have invented some unique ideas, and they can directly take the license of those unique ideas, and it in turn helps them or to big companies to stay in market in a competitive position. How? By coming up with new and new technology or features in their existing product. That helps to stay in market, or we can say to stay in a competitive position, competitive marketing. That is what we mean by. Now there are some disadvantages also with respect to licensing. Let's discuss the disadvantages of licensing. The first is, it might possible if I hand over exclusive rights of my intellectual property to some second or some big company, I might lose my control over that particular intellectual property for a defined time period, which we have mentioned while signing an agreement, based on which agreement we basically give license to some other party. So license, basically terms or type of license, is defined under a legal document which is called as agreement. Now when I forward or when I give my exclusive right over my intellectual property to some third party, I might lose my control over my own intellectual property or over my own invention. That is the biggest disadvantage. Now if you want to listen to what are the exclusive, non-exclusive and sole licenses, you can just go and search my previous videos. Basically I'm also providing link for the same video in description section. And one more thing, that very soon I'm going to upload the document. You can just find it out in any single video's description, on all the video series, all the videos of this particular series. In description section I'm going to provide you the link from where you can download the same solution for this paper. I hope it is clear. Now second point, there might be great risk of piracy and exploitation by unauthorized parties. Obviously someone might exploit the same property without your knowledge, without your consent. So that is also a second biggest disadvantage. Now next is, it is possible that the licensee develop technology around the product he has the license for and make the original licensor to lose his superiority. Now after making some small or some big changes in existing idea, he might applies his own control, or he might start saying that it is his own invention where he have modified my idea. Now he is not going to give me any profit out of that product's earnings. So that is also one of the biggest disadvantage. Next point is, for the licensee, the technology may become redundant in short span of time, and he may have to go for a new one at higher prices. As we know, often people gets bored using the same smartphone or working on the same technology or working on the same type of GUI, and hence they need something new after every some point of time. So whenever we start working with any technology based product or idea, it might not it might be not long lasting. So in short duration, we also need to add or manipulate the same idea. We have to add some new feature in the existing idea. So this is also a biggest disadvantage, that I have invented something after the research of 1 or 2 years, and now that idea stays in market for very short duration, that is 3, 4, max 6 months. After that 6 months, or within that 6 months, I need to show some modification or some, I have to add some extra feature in the same product. Now the last point here is, in case the technology is not tested, the licensee will at great risk of losing the money if relevant risk. Okay, so basically what this point states, that if we have not tested that idea properly, and without testing, if some company purchase the idea and after purchasing that idea they might find that this idea is not so useful and it might not possible to earn profit which they have imagined during purchasing the intellectual property. So this might be again one of the biggest disadvantage. So here we are done with question 4, sub question C. I hope disadvantages are very clear to you. And for advantages, you can refer my previous lecture. Now, question 4, sub question D. Here they have asked a question like, list out the criminal remedies in enforcing IPR, that is intellectual property rights. Enforcing, remember, we are enforcing means compulsory, you have to follow some rules, compulsion. That is what it states here. So some criminal remedies means if someone actually attempts or actually try to create pirated copy of some intellectual property, or broadcast the movie without permission of director, producer for his own commercial purpose, or a person who exploits any type of intellectual property without the knowledge or consent of intellectual property owner. So those type of people who knowingly attempts some very big, very huge type of crimes, because of which company faces huge losses, revenue losses, and that type of persons are called as criminals. So basically, if someone violates intellectual property rights, or in law term we call it infringement of intellectual property, infringement of copyright, infringement of patent, trademark, or any other type of intellectual property, or any other category, what we say. So let's start discussing criminal remedies. So there are first, I have listed out one point. As you can see, I have mentioned everything in point wise only. This is first point, second point, and in second we have 4 sub points. So let's start with the first. A criminal complaint can be filed either before the police or magistrate. Now, and they got right to search and seize those particular properties. Now, basically, if I explain this particular point, criminal, if I file a complaint against any person who have generated many duplicate copy of my movie or my song or my software, so at that point of time, where I need to file a complaint? In cyber cell, remember, or in intellectual property tribunals. Remember, intellectual property tribunals. This is the place where we actually need to file our cases. So in this particular case, if I am creating multiple copies of some CD, then without wasting time, those police officers or magistrate can directly go for a raid and they seize all the evidence with them. So they don't need to go and ask to some court for warrant, because till that point of time, it might possible someone vanishes all the proof or evidences. So to hand over someone or catch someone with red-handed, we have to immediately go and search or seize those things. That is what it says here. Then second, what are the benefits? Proper judicial determination. Obviously, we can actually assure, or we can actually go and file a case, and in return they are actually going to take some action. So that assures or that gives feeling of relaxation to intellectual property owners. Likelihood of earning damages if that criminal violated intellectual property right, and because of that I face 10 lakh rupees 10 lakhs of loss, then I can claim the same in a courtroom, and it might possible that all the losses are recovered with the help of court. Less subject to challenge, obviously. Once the decision is made from magistrate, then you have to follow it. So less subject to challenge. Commissions sees the orders are most respected. Now next points given here. Second is disadvantages. As we know, in India there is always delay in cases, decision of cases, and as we know one statement, delay justice is if justice is delayed means justice is denied. So we have to try to resolve those cases as soon as possible, otherwise those courtrooms are useless. So delay in trial, appeal, or if we go to Supreme Court, so delay in justice, that is the biggest disadvantage in India. Damage is not usually avoided. It might possible that I face 100 crore loss, but a person who violated those things, he's not be able in a position, he's a middle class person. So how can court sanctions those type of penalty on that person, because he's not be able to pay it. So damage, all the damages which I faced, it might not possible to recover all the damages. No severe punishment for violation, right? So if I got heart attack because of those losses, so it might those things are not written down here, and in that case we basically use IPRs, Indian Penal Code sections also we apply in this particular criminal case, that is half murder, and based on that case goes on. So in intellectual property rights we have not mentioned any such things. Now section 63 of Copyright Act, which states that defining offense of infringement of copyright, if we violate or break any copyright rules, then infringement of copyright is cognizable offense. Punishment, what is the punishment? Imprisonment means jail term up to 3 years and fine up to 2 lakh. Remember, maximum is 3 years jail and maximum fine is 2 lakh. So if we have performed very small crime, then based on that our imprisonment or punishment or jail term might vary. At the same time, fine also might vary. I hope these points are clear. Now the final point here, the minimum penalty. Minimum penalty under criminal remedies is 6 months imprisonment and 50,000 for trademark. Remember, we have already discussed for copyright here. So in case of copyright violation, 3 years jail, maximum 3 years jail and fine up to 2 lakh. In case of trademark violation, they have 6 months imprisonment or jail term and 50,000 as a fine. The maximum penalty for trademark violation has been increased from 2 years to 3 years and fine up to 2 lakh. So remember, this is minimum penalty for 6 months. Maximum before it was 2 years, and now in the new trademark amendment we have increased the same duration to 3 years, and fine also we have increased to 2 lakh rupees. And last thing, 7th point is trademark violation is not cognizable and non-bailable offense. So you won't get bail up till the point your the final decision comes. The bill now empowers police officer not below the rank of Deputy Superintendent of Police. Remember, DSP, not below the rank of DSP have right to search and seize without warrant. So only DSP. In cyber cell, only DSP got this permission to go and search and seize any evidences or any place without warrant. If you find violation of any type of intellectual property, you don't need to go and ask magistrate or some court or some tribunals, intellectual property tribunals, to issue warrant against that particular party. No, you can directly, DSP can directly, cyber cells DSP can directly go and seize that particular place, and then they file the same case to some court or district court or to some magistrate. Remember this. So this is the most important point, and rest of the things are very simple and they are self-explanatory. So I hope this video is surely going to help you out. Thank you.